This is Lee from the Law School Toolbox and the Bar Exam Toolbox. Welcome to another episode of the Substantive Spotlight series, where we are diving deep into criminal law. Today, we're talking about the elements of a crime and homicide, essentially how the law decides when someone has broken the rules and what happens when someone takes another's life. Think of it as a crime drama, but with more legal analysis and fewer commercial breaks. You know what's fascinating about criminal law? It's quite literally everywhere in our culture. Every time you binge a true crime series, watch a courtroom drama, or hear about a case on the news, you're swimming in the concepts we're discussing today. Understanding these fundamental principles will not only help you ace your exams, but also give you a whole new perspective on how society defines and punishes wrongdoing. So let's start with the absolute basics, the elements of a crime. Every crime, no matter how simple or complex, has four essential building blocks: the actus reus, the guilty act; the mens rea, the guilty mind; causation, linking the act to the result; and concurrence, the mental state and physical act happening at the same time. Think of it like baking a cake. You need all the ingredients, or it's just not a cake. The actus reus is what the defendant actually did, the physical act component of the crime. But here's an important point we covered in our Listen and Learn episode on elements of a crime. The act must be voluntary. Sleepwalking or having a seizure doesn't count. And generally, just thinking bad thoughts or failing to act isn't enough either, unless you had a legal duty to act. It's like the difference between imagining eating the last cookie and actually sneaking into the kitchen to take it. Now on to mens rea, the mental state behind the action. Under the common law, we have four main flavors of culpability: specific intent, you meant to do exactly what you did; general intent, you were aware of what you were doing; malice, reckless disregard for a known risk; and strict liability, no mental state required at all. The Model Penal Code specifies this into four levels of intent: purposely, knowingly, recklessly, and negligently. It's like a sliding scale of I meant to do it down to I should have known better. When you're analyzing a criminal law question, identifying the required mental state is crucial. Our Listen and Learn episode on intent under the Model Penal Code walks through this in detail, but here's a quick recap. Think about someone firing a gun into a crowd. If they were aiming at a specific person, that's purposeful. If they knew someone would likely get hit but didn't care who, that's knowing. If they fired recklessly without aiming but aware someone might get hit, that's reckless. And if they fired carelessly without realizing the danger but should have, that's negligent. Same action, four different mental states. The causation element connects the dots between what the defendant did and the harm that resulted. As we explored in our Listen and Learn episode on causation, we need both actual cause, the but-for test, would this have happened but for the defendant's actions, and proximate cause, was this result foreseeable? Think about it like knocking over the first domino. You're responsible for the chain reaction, but only if it was reasonably predictable. Does this sound like torts? Of course it does. Causation is important in a negligence analysis there as well. Finally, there's concurrence. The mental state and the physical act must happen together. You can't form the intent after you've already done the act, and you can't form intent, change your mind, but accidentally do the act anyway. It's like deciding to make a cake and then actually baking it. They need to be connected. Now let's talk about everyone's favorite bar exam topic, homicide. This is where the rubber meets the road in criminal law, and it's tested constantly because it has such a clear framework. Homicide is divided into two broad categories: murder and manslaughter. Think of it as a spectrum of culpability from most blameworthy to least. At the top, we have first-degree murder, followed by second-degree murder, then voluntary manslaughter, and finally involuntary manslaughter. Each has distinct elements that you need to know cold. So let's break down murder first. Under common law, murder is the unlawful killing of another human being with malice aforethought. That malice aforethought is the special sauce here, and it can be satisfied by 1. The intent to kill. Think, I want you dead. 2, intent to cause serious bodily injury. Think, I want to shoot you and really hurt you badly. 3, depraved heart, which is extreme recklessness showing indifference to human life. Think, I'm going to shoot into a crowd and I don't care what happens. 4, felony murder, which is a death during the commission of an inherently dangerous felony. Think armed robbery of a bank where someone dies during the commission of the robbery. First-degree murder typically requires premeditation and deliberation, essentially thinking about the killing beforehand, even if just for a moment. It's like the difference between impulse buying a candy bar at checkout versus writing candy bar on your shopping list before going to the store. Both result in a candy bar, but one showed planning. Second-degree murder is everything else that satisfies the malice aforethought requirement, but lacks that premeditation element. It's your base level murder, intentional, but not planned or extremely reckless, or during certain felonies. This brings us to voluntary manslaughter, a killing that would be murder but gets downgraded due to certain mitigating circumstances. There are 2 main paths to voluntary manslaughter. First, heat of passion or adequate provocation. As we detailed in our Listen and Learn episode on homicide, this requires 1, the defendant was provoked, 2, a reasonable person would have been provoked, 3, there wasn't time to cool off, and 4, a reasonable person wouldn't have cooled off. It's essentially recognizing that humans are emotional creatures and sometimes act impulsively when severely provoked. Think about the person who walks in to find their spouse cheating and then hits one of them with a baseball bat until he dies. The second path is imperfect self-defense. When someone honestly but reasonably believes that they need to use deadly force to protect themselves, regular self-defense is a complete defense, but imperfect self-defense just reduces murder to manslaughter. It's like getting partial credit on your exam. Finally, we have involuntary manslaughter, unintentional killings from criminal negligence, recklessness, or during a non-dangerous felony or misdemeanor. This is the oops, I really messed up category of homicide. Now, even when all elements of a crime are established, a defendant may have legal defenses available. As we covered in our Listen and Learn episode on defenses to a crime, these fall into 2 main categories: perfect defenses, which completely excuse the conduct, and imperfect defenses, which may reduce the severity of the crime. So let's start with perfect defenses. Self-defense is perhaps the most well-known. You can use reasonable force to protect yourself from imminent harm. The key elements here are 1, reasonable belief of imminent danger, 2, proportional response, and 3, in some jurisdictions, no duty to retreat. It's like your personal protection bubble. The law recognizes your right to defend it, but with limits. Duress is another perfect defense, requiring 1, threat of imminent death or serious bodily injury, 2, to the defendant or another, and 3, no reasonable escape except by committing the crime. Remember, though, most jurisdictions won't allow duress as a defense to an intentional killing. The law says, we understand you were under pressure, but taking a life is a line you still can't cross. The insanity defense is probably the most misunderstood defense in popular culture. Jurisdictions use different tests: the M'Naghten test, the inability to know the wrongfulness of conduct, the Model Penal Code test, substantial inability to appreciate criminality or conform conduct, the irresistible impulse test, inability to control actions, or the Durham test, conduct as a product of mental illness. It's not about whether someone has a mental illness. It's about how that illness affected their understanding or control at the time of the crime. Intoxication follows an interesting pattern. Voluntary intoxication is generally only a defense to specific intent crimes, and even then, it's limited. While involuntary intoxication can be a complete defense to all crimes if it meets the same standards as insanity. It's like the law saying if you choose to get intoxicated, you're mostly responsible for what happens next. Remember, too, that mistake of fact can be a defense if it negates the required mental state for the crime. If you genuinely believed you were taking your own umbrella, though it was actually someone else's, you lacked the intent to steal needed for larceny. Mistake of law, however, is rarely a successful defense. The old adage, ignorance of the law is no excuse, holds true. For homicide specifically, justification defenses like necessity, public duty, and self-defense can completely excuse a killing. But don't forget imperfect defenses like heat of passion, which we discussed earlier, and imperfect self-defense, which can reduce murder to manslaughter when someone honestly but unreasonably believes deadly force is necessary. So now here's your quick attack plan for analyzing homicide questions on an exam. 1. Start at the top with first-degree murder and work your way down. 2. Look for keywords like planned, deliberate, or lying in wait for first-degree murder. 3. Check for heat of passion or provocation language for voluntary manslaughter and make sure you look for things that relate to reasonableness. 4. Watch for accidents, negligence, or recklessness pointing to involuntary manslaughter. 5. Always consider whether any special rules like felony murder might apply. 6. Don't forget about causation, especially if there are intervening acts. And 7. Look at defenses that may apply. Want to really master these concepts? Our Listen and Learn series has you covered. Start with our episode on elements of a crime for the fundamentals, then dive into homicide to understand the different degrees. Our episodes on the Model Penal Code will help you navigate those different mental states, and don't miss our episodes on defenses to a crime for when you need to argue the other side. We will link to all these episodes in the show notes. Stay tuned for part 2, where we'll jump into property crimes and inchoate offenses. Because let's face it, there's more to criminal law than just homicide, although you wouldn't know it from many law school exams. We'll talk about theft crimes, burglary, arson, and all those almost crimes, like attempt, conspiracy, and solicitation. Thanks for watching, and be sure to subscribe, give us a like, and leave us a comment. Until next time.